Now back to the show. This is The Law Show on CL 650.
The Law Show here on CL 650, immigration law, and we're in our final segment of this week's show, and we're picking up on where we left off just before the break. We have Gordon Maynard here and Rudy Kisher from MKS in downtown Vancouver, immigration specialists, and we're talking about the LMIA program. Now, we talked about foreign workers coming in, but there's this other group of people. How are they affected?
Well, these are the IMP workers, the International Mobility Program. These are workers who come in and they're not required, nobody's required to obtain an LMIA. So
they're separate from LMIA. Okay.
They're separate from LMIA. They're LMIA exempt,
okay,
we say. So this includes intercompany transferees. It includes free trade agreements where certain professionals can come in and access the Canadian labor market. So last February, a year ago, the government put in a employer compliance regime for people with these kinds of work permits. And if you were an employer in Canada who's going to bring in some of these workers, you had to go register on the government account. You had to set up an employer account on the internet at the government website. And if you're bringing in a worker, you had to register your offer of employment to that worker. So recently, and this is not uncommon for people in our business, we're dealing with Canadian businesses that are using the free trade agreement, and they're bringing in an engineer, or they're bringing in an IT specialist. They're contracting with a U.S. company to send someone up to help fix their company-wide IT system. And these people are entitled to a work permit under NAFTA to come and do that for whatever amount of time, 2 months, 3 months, whatever it's going to take. This company in Canada contracting those people has to register as the employer of that worker. They have to pay $230, create a government account or an employer account on the government website, and then they have to put in the offer of employment. But they say, I'm not the employer.
They're employed by a U.S. company.
The U.S. company is paying the salary. This isn't my employee. Mm-hmm. And the government website says, we know this isn't your employee, but you still have to do this. And you still have to commit to these compliance obligations. You have to commit that the employee, while they're up here, is going to be paid the salary that they're supposed to be paid. How in the world can the Canadian employer make that commitment? Mm-hmm. And so obviously some Canadian companies are balking at this. It still says this on the government website. It still says you have to do it. You're the employer for the purposes of this. But the government quietly is saying, we'll let the American company set up the account, but you can't find this said on the government website.
Well, I can see this being a real problem for consultants, right? So you've got a U.S. consultant coming up to help consult for your new IT program or whatever it is, right? And so you're saying in order to get them up here, you have to act as an agent almost for them.
I got to step in as an employer and take on all this sort of commitment and language and baggage of keeping your records and making sure you got paid correctly. When actually,
and the risks.
I've got no responsibility for that. And who are we protecting? Is my question. It's such a waste of taxpayer dollars, and it's making it harder for commerce to go across the border.
And are these typically higher paid individuals?
Yeah. These are professional occupations, or they're senior management intercompany transferees.
So this is back to your point before the break, Rudy, is that did they really need protection if they're making $150,000 a year as a consultant on a project or something?
Exactly. They don't need protection, number one. Why is the government having to step in on that respect? You know, and it's the sort of what we've seen happen in the past is a little bit of bad press. And instead of addressing the issues in a logical fashion and sort of saying, well, this is kind of what we need, it's the big hammer to kill the fly, and they've put it in a broad approach, which is affecting everybody and hurting the sort of, you know, the more sophisticated worker that really doesn't need our protection.
I would assume that we have an immigration act that covers all of these things that's kind of set. But it seems to me that it's a moving target all the time. Was there a time where we had a static kind of immigration policy for all of these things?
Yeah. We used to have an immigration act that was, you know, governed mostly by regulations, and regulations have to be passed before Parliament, right? Mm-hmm. So there was some debate about this, and then you could actually plan, talk to your client, and have an idea that, well, listen, you may not qualify today, but you may not get it processed today, but we know you qualify, and therefore eventually your application will get processed. You know, Jason Kenney, the Minister of Immigration, thought we needed what he called nimble responses. Immigration, we needed to be fast and nimble in terms of
But
timely.
was there a problem before that?
Well, I think there might have been a little bit of time since the government wasn't responding fast enough. So what they did is they totally removed Parliament from the process and left it up to what's now called Minister's Instructions. So instead of any debate, what we get coming across our office now is an email on the CIC website. Basically, this is how we're doing things now.
A bulletin.
Yeah.
Yep.
And that's it. No debate. No
Minister's
consultation.
instruction.
But that minister has a lot of power, and they've just been bestowed that power because they've been assigned that portfolio. They don't really, they're not experts, really, are they?
Yeah, no, they're not.
And what happened was when the act was put in place, when the Immigration and Refugee Protection Act was revamped in 2002, this is where you saw reference in the act to the authority of the minister to act under minister's instructions. And at that time, there were very few minister's instructions, very few. But the government was warned by critics that this is going to be a process that bypasses the parliamentary system or the Canadian Gazette, the regulatory provisions, the requirements there to publish and to have dialogue on it, review. Ministers are going to be able to take areas of conduct and simply issue instructions that are going to change the way business is done without any review in Parliament and no review with public debate. And that's exactly where they've gone. The whole express entry system that we have in place to manage our immigration selection process was done by ministers' instructions that weren't made public until December, December of 2000.
Yeah. So you think about our whole, how Canadians are chosen, right? We set up a whole parliamentary system, debated the numbers and everything else. How are we going to select people? And the minister, at a stroke of a pen, said that doesn't matter. We're going to prioritize in the way we think it's appropriate. And you guys can go suck your thumb in the corner because it doesn't matter what Canadians think or anybody else thinks. We're gonna tell you who we're picking.
Is there any more you guys want to talk about employer compliance? Because we want to we don't have a lot of time.
It's an ongoing issue, but let's talk about changes coming up in family class.
Yeah, so family class is obviously important because this is this reunification? Is it part of that?
Yeah.
What does that mean?
Yeah, so family class applications are generally, it's very limited. People think family class, can I bring in my sister? Can I bring my uncle? No. Family class is very limited in Canada to generally your spouse, right, or your dependent children. So that's all family class
parents
really
and grandparents.
And then parents and grandparents, which is very limited.
So that's
right?
your nuclear family.
That's your nuclear family. And that's the only people you're allowed to sponsor. So that's it, So it's not a big class. And what we saw happen in the past act, they brought in changes in which if you were sponsoring a spouse and you hadn't been living together for 2 years and you weren't married for 2 years at the time of the application, they brought in a requirement that you actually have to live with the person who sponsors you for 2 years, or you could face deportation. Right? And the reason this came about is there was a massive problem that was seen as a massive problem. Is there were a lot of marriages that were done for fraudulent purposes. Maybe not by both parties, but by one party thinking, well, I'm going to get this advantage of coming over here, get my Canadian permanent residency, and then I'm not really going to stay with that person. And the problem is trying to remove somebody after that. You'd have to go show that the relationship wasn't genuine, and that was hard to litigate. So they thought, we're going to get the government thought we'll get rid of that litigation part, but we'll make it mandatory that you have to stay with people. So what I've seen in my practice is people coming forward, an American guy meets a Canadian woman, moves up here, gets a job up here, they fall in love, she sponsors them, they haven't been living together for 2 years, or they've been, maybe living together for a year, they don't meet that criteria. Well, guess what? He's been married twice before, he's not exactly Romeo, it doesn't work out, and all of a sudden he's like breaking up, he's got a great job, wants to stay in Canada. All of a sudden we're in litigation because, the wife was unhappy, writes a letter to immigration saying this guy's left me. Immigration's on his doorstep, said you guys didn't stick together for 2 years, and now we're in litigation. And there's actually, it's a cost, and I think an unnecessary cost again.
Well, the worst situation is if a vulnerable person comes into the relationship, they're sponsored into Canada, and then it becomes an abusive relationship.
So they're staying together because of the law.
Yeah, there's pressure on that person to stay in the marriage because if they don't meet the 2-year rule, their status is only conditional. So now there's pressure for them to stay in their relationship or they're going to face deportation.
Now, in fairness to the Act, there is provisions there that if you are being abused, this doesn't apply to you. But now you've got to make that case. How do you prove that? And you got to make so you're nervous the whole time. Well, it's my word against his word. And guess what? All his family's here. None of my family's here. And they're going to say, well, He never did that, and what are you talking about? So these poor women, you know, often women sitting there forced into a relationship on this provision that, again, goes back to a comment I made earlier. I think you want to make the clearance at the front end, make sure we have a generalization, and then once they're here, let people, unless you see fraud, let them continue in their relationship. I don't think forcing someone to be together.
The whole idea of bringing in the 2-year rule was to make it easier to take status away from somebody. You can always take status away if you think it's a marriage of convenience. But you have to demonstrate, satisfy the tribunal that it was a marriage of convenience. And that's not hard to do. It's not, it's not difficult. If you have evidence of it, bring it forward, and the test is not that high. If the tribunal thinks it was either not a genuine marriage or that the primary purpose was to gain status in Canada, they'll say that that marriage was fraudulent and the person should lose their status. But they brought the 2-year rule in to make it simpler, and it's turned out to be not such a good rule. So they're going to remove that rule, and that's probably a good idea.
So in our last minute together, always looking for free advice from lawyers, which is good to get. We've had a whole hour of it, I'm joking. But if somebody is working with a company to come into the country, a family matter, what's your advice to them? It's always good to get an opinion, right?
I think don't wait till the last minute. If you get a letter, if you're an employer and you get a compliance review, don't try and answer that yourself. I think you might be stepping into a quagmire now with almost $1 million in fines possible per employer. It's worthwhile calling somebody up. Call us up. We'll set down a consultation and go over your possible options before you respond.
It's always good to get, at the very least, discussion on timelines. Business always operates at their own speed, and quite often the last thing they do is think about the immigration side of it.
And government works on a whole other speed I'm learning about.
It's become a very, very complicated and often time-consuming process. So get advice early so that you can make your business plans and your plans for entry of the individual in a timely manner.
All right, and speaking of time, are out of time. Thank you very much. Gordon Maynard and Rudy Kitcher, thank you so much for being on the show today. We've been talking about immigration law. The firm is MKS in downtown Vancouver in Yaletown. We're going to have the gentleman back again. The Law Show on CL 650. I'm Zach Spencer. I'll speak to you next time.